Hi, I'm attorney Cory Carlson. In this video, I want to talk about personal injury law in the most general sense. And the reason I want to talk about this topic is because I get calls from people all day, every day who have potential personal injury cases and they want to get a consultation with me. And it's always surprising to me how little most people in the public understand about personal injury law. What limited information they do have oftentimes is wrong because there's all these misconceptions out there. And it occurred to me one day that that's not their fault. It's my fault. It's the legal profession's fault. And even though I'm a practicing lawyer, even though most of the people I know in my professional life are lawyers, I'm very critical of the poor job that we at the legal field have done in educating the public, and we mask what we do behind technical jargon and impenetrable language. And I think that needs to stop. So what my goal here is to talk about personal injury law so that by the end of this video, you know what it is, you know what the moving parts are, you're conversant in it, you know why it exists, you know what its purpose is, and you feel a little bit more connected to the American legal system and less like someone on the outside looking in. And if I've done my job right, you'll be able to go out and tell other people about what you've learned, and it'll make sense to them as well. So let's jump right into it. What is personal injury law? Personal injury law is not a law. It's not some sheet of parchment in some museum somewhere that has some personal injury rules written on it or anything like that. The term personal injury law is a category. It's a way of describing a very big thing that has lots of tentacles and lots of different moving parts. And we categorize it as personal injury law because however different all these little components may be, they all serve one overriding goal. And that goal is that when someone is wrongfully hurt, we want them to receive fair compensation. Now, right out of the gate, we got a problem because what does wrongful mean and what does fair mean? And you're going to find out that in any given state or any given jurisdiction, there are different conceptions, different ideas of what fair is, different ideas of what wrongful is. And we have many instances in the law where something that you or I may think, hey, that's totally fair. Lawmakers have decided we're not going to let you do that because we think it's unfair to someone else. Now, that's a realization that can be had about just about anything in society, right? You can look at most laws having nothing to do with personal injury and, election laws, for example, and you can say, okay, well, we want to protect the sanctity of elections, and so we have a rule requiring people show IDs. Well, hang on a second, that rule requiring people to show IDs, what if that unfairly harms elderly people who have more difficulty getting down to the driver's license office and getting that ID or whatever? And it's not uncommon that within society we have competing groups and there is no one-size-fits-all answer that's going to make everybody happy. Well, personal injury law is no different. What I'm going to represent to you, however, is that on net balance, personal injury law is pretty darn fair and balanced to all parties involved. And we're going to delve into some of that. I'm going to give you some examples and you're going to see. But just understand that, again, the thing we call personal injury law is actually a whole bunch of different independent laws that all work together and can be categorized under this heading of personal injury law for the purpose of trying to make sure that when someone is wrongfully hurt, they receive fair compensation. The inverse of that is if they weren't obviously or wrongfully hurt, then we don't want them to get fair compensation. Or if they were wrongfully hurt and they want too much compensation or that someone wants them to have too little compensation, we want to fix that as well. So the whole goal of the system is to just try to thread the needle and find something that is societally acceptable to the greatest number of people and that does the greatest amount of good. To understand how personal injury law came into being, we need to look at the history a little bit. And if we go back all the way to the earliest days of the history of the United States, you're going to find out real quick we have not gone back far enough because personal injury law is actually a lot older than the United States. If you may recall, or as you may recall from a high school history class, the United States of America started out, of course, as colonies from multiple different places, but the 13 colonies that ended up becoming the United States were essentially English. And so on day one of any of those colonies, a big chunk of English law came across with them on the boats. And so when they entered into contracts, when they injured one another, when they had a divorce or anything along those lines, it was done pursuant to English law. So to understand where we're at in 2026 in American personal injury law, we got to hop back on the boat. We got to go back to England, and then we need to go back about 1,000 years. And I could talk about this stuff all day. I'm not going to get too far in the minutia. Maybe we'll do another video on that where we really dive into medieval legal customs. But for now, we're just going to talk about it at kind of a high level. So if you go back hundreds and hundreds and hundreds of years in England, what you're going to find is that people would hurt one another unintentionally. Okay, if someone hurt somebody on purpose, well, then there would be different legal recourse. You'd file a lawsuit against them, sure, but you could also have them thrown in jail. Okay, what started to emerge was this idea that, well, wait a minute, not everything is done on purpose, right? The Supreme Court Justice Oliver Wendell Holmes famously said that even a dog can tell the difference between being kicked or tripped over. And out of this idea came a need to make sure that when someone is harmed, that fair compensation is available to them. And so mechanisms had to be invented to allow that to happen legally. Okay? The idea that sort of emerged in medieval English customs and legal customs was the idea of trespass. Now, we all know what trespass means kind of just intuitively, I guess you'd say, or colloquially. We think of it as someone coming onto our land. And the English thought of it originally as in those terms as well, but then they said, well, wait a minute, can't you trespass on my person? Can't you unintentionally cross that imaginary border onto my personal body and inflict some kind of harm on me? Why should I be able to sue you if you walk across an imaginary line that I call my property line, but not sue you if you come up and trip over your shoelaces and shove me down a flight of stairs? Why can't I sue you then? And the court understood that, and what emerged was various different types of trespass-based causes of action. Now, pause real quick. A cause of action is like a basis for suing. It's like think of it as your right to sue, your thing that you're suing for, and most importantly, for it to be a cause of action, it has to be recognized by the court. So if I show up at court and say, you know what, I'm going to sue that person for improperly smiling at me. Well, improper smiling is not a cause of action that the court recognizes, and so you can't sue the person for that. You file your suit, the court's going to reject it. Okay. Back in those days, a trespass lawsuit became the primary cause of action by which you would hold someone accountable for unintentionally hurting you, or in some cases even for intentionally hurting you. So you can intentionally trespass on an individual, or you can unintentionally do so. That existed in some form or another for many, 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 many years. What eventually happened on this side of the Atlantic Ocean, and also in England, sort of simultaneously, is this notion of maybe a little bit more of a nuanced understanding of how accidents occur. And that is what we refer to as the idea of negligence or negligence law. Okay? Negligence, as we sit here in 2026 and look back, was a revolution in the idea of personal injury law. The way that trespass had always been applied to resolve personal injury issues was very formal and rigid. And in England, they had pre-made writs. And a writ was essentially like kind of like we would use a lawsuit today. You're basically filing something with the court, asking the court to do something. And these writs were incredibly mechanized. English lawyers had to know every single word down to the most minute detail, because if you filed a writ and it was supposed to say A, B, and C, and you said B, C, and A, the court could reject it. It became like this very rigid, mechanized process. Well, in the 1800s, there was a pioneering lawyer, I believe his name is Fields, who came up with an alternative way of doing things. And he said, hey, what if we get rid of this writ system? What if instead we use something, a lawsuit which already existed, and we just make it a lot more general? People just have to lay out what it is that they're complaining about and ask for some kind of relief, some sort of outcome that they're looking for from the court. And the court can view this without having to get wrapped around the axle on all this like super technical stuff. Okay. Well, I don't think it's a coincidence that that came from the same era that negligence law came from. Okay. And there was this atmosphere of like, hey, let's tone it down a little bit and make it less this hyper technical exercise, and just make it like, hey, people talking to the court. And still there's some legalese, there's some jargon, but let's dial it back a little bit. So you have a famous case, which we're not even I don't intend on giving case names and all that. This isn't a homework assignment where you're going to go out and do more research. It's just to talk about the general ideas. There was a famous case from the other side of the pond where a barrel rolled out of a window and fell and struck someone in a street. It rolled out of like a second floor window and struck a person. And it ended up being a scenario where it's like, well, they didn't do it on purpose. It doesn't really fit into the mold of like one of these trespass actions. So what do we do? Does this injured person have any legal rights? And the court basically said, yeah, they do. By being neglectful, by failing to exercise what a reasonable person would do under the circumstances, that is a wrongful act. And we call that wrongful act negligence. We say that, and negligence and neglect, they have kind of root words. They're basically saying you have neglected to behave the way society thinks you should behave, and that is the thing that makes you liable, not all this ancient stuff that we've been talking about all these years, okay? In America, similar developments were occurring. And it's really funny, if you talk to a lot of people today, particularly people who are critical of lawsuits, they look back on that and they think of it as like, oh, there goes the neighborhood. It used to be so formal and rigid and strict. And they invent this freewheeling idea of negligence, and now anybody can sue anybody for anything. Well, a couple thoughts on that. That's actually the opposite of the intent of negligence. One of the unintended side effects of the trespass rules is that we didn't really put a whole lot of thought into why or how it happened. It's just, did you do it? And so you had lots of instances where somebody barely did anything wrong, but they technically met the definition of having trespassed against an individual, and so they'd get sued and have to pay a bunch of money, and that was kind of burdensome. The idea of negligence is we put in a new requirement. We said, well, we're kind of getting away from this trespass stuff. A person is not liable just because something bad happens. You have to instead meet this higher burden of showing that they shouldn't have done it, that they should have behaved differently, and that society expects them to behave differently. And now, because they failed in that responsibility, that's why they're liable. So negligence was actually a way of making it a little more difficult to sue people. Okay. The other thing that I would say is that the notion that people are suing each other left and right, and everyone has heard the phrase, America is such a litigious country and all that kind of thing, and they blame it on people like me, trial lawyers and that sort of thing. That's actually something that's somewhat ignorant of history. If you go back in time to the colonial area, those people were suing each other like it was going out of style. Okay, and in fact, one of the primary sources of information that we have about life in that area comes from the civil justice system and from the criminal justice system because of the record keeping that they kept, and probate matters, with respect to administering people's wills and that sort of thing. And that stuff still has bearing today. The U.S. Supreme Court often cites to someone's will, for example, in order to determine what was considered normal with respect to firearm ownership in those days, or whatever the topic may be. Okay. I'm going to give you an anecdote that's one of my favorite anecdotes, and I have to use a little bit of potty language here, so bear with me. So there's a book called American Freedom, American Slavery. And I won't get too far into the details, but it's basically a book about that era and talks about kind of how slavery existed alongside sort of an unprecedented amount of freedom, and how there was that inherent contradiction and all that entailed. What a lot of people are not aware of is that in the colonies, particularly in Virginia, prior to a certain point, there were free African Americans who had, for all practical purposes, the same rights as everybody else. I'm not in any way downplaying the horrors of slavery. I'm just saying prior to that, a lot of African Americans were able to live and own property and work their farm just as anyone else. And one such example that I always find so fascinating is that there was a summons that was attempted to be served on a guy, and if I remember correctly, he was a witness to something that happened between two other individuals, and his name was Tony Longo. Tony Longo was a free black man, and he lived with his Irish wife on his farm, and an officer of the court was complaining to the court about how he had been treated when he went to Tony Longo's farm. Well, it was harvest time. Tony didn't want to be bothered, and this guy showed up and said, hey, you got to ride into town and you got to come testify in this case. And he said, no, I'm not going to do it. And as the gentleman reported to the court, he said, I informed the said Mr. Longo that I had a warrant, and he said, be gone, you idle rascal, I want shit of your warrant. I like that story for a lot of reasons, but that's I think kind of illustrates the point I'm getting at, is that early on, before Virginia and other states instituted codes that really put this harsh separation between the races, there were African Americans who participated in court processes and later were denied. And so from this time period, you had so much that was going on in terms of legal activity that their rate of litigiousness was substantially higher than it is in America now. And as you know, America is higher than it is in a lot of other countries. So this notion that like negligence law ushered in like this unprecedented era of people suing people, it's not actually historically true. It was the case that in the founding era, they were pretty happy to sue one another and did so with great regularity, despite a lack of laws that made it easy to do so. So I digress. The point I'm making with all of this is that when negligence came onto the scene, this concept of negligence, you failed to act as a reasonable person would, and therefore you're liable, originally it was meant to be a roadblock to keep people from suing. As it has evolved over time, it's the main way that you sue people now. Okay, and so we're going to talk about other ways of suing people, but suing someone for negligence is really the Honda Accord, if I may, of personal injury law, in that it is the most common, ubiquitous way that people sue one another. So let's talk about what negligence law is, since it features so prominently in American personal injury law. Negligence essentially is the idea that you didn't behave the way a reasonable person would have behaved under the circumstances. Who gets to decide who the reasonable person is or how a reasonable person would act? Juries, typically, right? You can have bench trials, which is where the judge conducts the trial and acts as the jury. You can have certain hearings on minute issues in cases where the judge is the jury for judging that particular portion of it. But by and large, juries decide what's reasonable. And that does two things for us. One, it I think is the perfect way to illustrate how negligence law works, and so I'm going to circle back to that. But it also brings up a really interesting point, and that is that 12 people on a jury in Maine may see what is reasonable very different than 12 people on a jury in Dallas, Texas. And 12 people on a jury in Dallas, Texas may see what is reasonable very different than 12 people in Burleson, Texas, just a small town a few miles down the road. That regional variance is something that a lot of people lament, and they go, oh man, it makes it so hard to predict what's going to happen. But I think it's actually one of the unintentionally inherent beautiful aspects of our civil justice system, is that people from the community get together to decide how things should work in their community. I'll give you an example. Let's say that someone is walking a horse, they're holding it by the reins, or walking a horse down the road in downtown Houston, Texas. And there's a person standing on the sidewalk. As the horse passes, the person walks behind the horse kicks them, and they become very badly injured. They sue the horse owner, it goes to a jury trial in a Houston court, and the jury is very critical of the horse owner. You should not have had that dangerous animal out by a bunch of pedestrians in the middle of the day when you know people are going to be walking around. You need to pay the guy. But then let's say that the exact same thing happens, only this time it's in Hamilton, Texas, a small rural community. The people in Hamilton, Texas, they might be a lot more accustomed to seeing horses about. The way that their society functions, they may just sort of understand, unspoken, that if a horse just passes by, you got to give it a little space before you walk behind it, because the horse may kick you. That exact scenario may happen in downtown, the downtown square in Hamilton, Texas, on any given day. Someone gets injured, they sue, and the jury of 12 people in Hamilton says, no, sorry, it's your fault. You shouldn't have gotten that close to a horse. Everybody knows that. Is one right and the other wrong? No, I think that, again, that expresses regional variations and regional understandings, which is an inherent part of living in a complex society, right? If you have people who live miles apart and have different cultural norms and different values, of course they're going to think what is reasonable is different. And we want to put in some guardrails, right, so that they don't do things that are manifestly unjust, right? And say, well, if a Caucasian person had gotten kicked by the horse, we'll give them money. But if an Asian person got kicked by the horse, we're not going to. Okay, we don't want that, right? We got to have some guardrails so that the juries are not behaving in a prejudiced manner against people that's just inherently unfair. But aside from that kind of extreme stuff, you want to give the jury the freedom to decide what they think is reasonable. I'll give you another example. We had a focus group recently. My law firm is representing the family of a man that was killed in a truck accident where he was driving his motorcycle down the highway and a truck came from a side street, sort of rolled through the stop sign, and then the motorcyclist struck the side of the truck. Well, one of the issues that came up in that case is that the motorcyclist wasn't wearing a helmet. Now, between you and me, it wouldn't have made a difference given the collision, but we didn't get into that with the potential jurors in this focus group. Instead, we presented the evidence in a neutral fashion and asked them, do you put any blame on the motorcyclist for not wearing a helmet? Now, the difference between a focus group and a jury is that the focus group, they just get to talk freely, right? They get to ask questions. And what we found is that there were 4 people in that group that were very critical of the motorcyclist for not wearing a helmet. And then everybody else out of a group of 15, they all thought that it didn't make any difference in the accident. And so they weren't willing to put any blame on the motorcyclist just because he didn't wear his helmet, okay? Who's right and who's wrong? They're all right. There is no correct answer. It's a value judgment. And that, I think, is really an important thing to understand, is that when you're dealing with the idea of negligence law, and we're asking, did the person accused of doing the bad thing, did they behave as a reasonably prudent person? There is no textbook answer. There is no specific legal answer. There's no rule. There's no law. There's no overriding concept that can answer that question 100% of the time. Instead, what you have is normal people sitting on a jury and deciding what they think is reasonable. And that, my friends, I think is something that makes our system so good. I don't view that as a negative at all. I think that that's a positive, because those individuals are playing a literal role in shaping what society should be like. If you don't like what those individuals are doing, then get off your lazy butt and go be a juror in a case, and you get to make that determination. Okay, so within this idea of negligence, we're going to talk about something that's a little bit technical, but I'm going to keep it simple, and that is the idea of case elements. Okay, so for any cause of action, if I sue somebody for negligence, if I sue them for some specific type of negligence like medical malpractice or anything like that, we have a list of things that I have to prove as a lawyer in order to establish that they did the thing I accuse them of. And we call those things case elements. I think it's easier to understand that in the criminal context and then kind of bring it into the civil context or like lawsuit context. Let's do that. We've all heard, detective shows, cases in the news, that sort of thing. They talk about murder in the first degree, okay? And a lot of people go, well, what exactly is murder in the first degree? Or they talk about, manslaughter instead of murder, or they're pursuing the guy for murder, but the jury may decide it was only manslaughter. We can spend all day talking about that, but the bottom line is there's a difference between different kinds of killing people, right? We recognize that a husband that comes home and finds his wife in bed with another man and goes berserk and beats that man to death, that's similar but different than a guy who kills an innocent person in a drive-by and shoots them by mistake. Or different than someone who drowns their child in the bathtub, or different than someone who robs a liquor store and shoots the clerk, right? So we have these different levels of homicide charges. And the thing that makes them different is they have slightly different elements. And we're not going to get, again, too lost in the details on that. But let's just say, and I'm going to make this up just because, again, it doesn't matter. Let's say that what we call in an imaginary state, the state of, whatever, Mr. Rogersville, okay? In Mr. Rogersville, we say that if you intentionally kill someone and it was premeditated, you have committed murder in the first degree. Okay, our lawmakers get together, they come with those requirements, those case elements. Intentionally kill someone with premeditation, meaning you thought about it beforehand, okay? And then we say manslaughter is when you unintentionally kill someone while breaking the law, okay? And again, these are not actually how it works in real life. I'm just trying to simplify. We would say that the elements that need to be proved to either count as murder in the first degree or manslaughter are very different. There's some overlap. They both involve killing someone, but one is intentional, the other is unintentional. One is you do so with forethought, you think about it, you plan, you scheme against that person, and the other one is you're just doing something illegal. So we got a scenario where a guy's driving down the highway, and he is street racing. He's got a fast car. He sees somebody else in a fast car, and by God, he's not going to let them pass him. And so these two fools are speeding down the road. They lose control, crash into an innocent person, and kill them. Gentleman gets arrested, and they go, you know what? We're going to prosecute this guy for murder in the first degree. Now, your spidey senses should be tingling right now because you go, wait a minute, it wasn't intentional, and it wasn't pre-planned. He wasn't like sitting there scheming to run into that minivan and kill those people. The only thing there that can be proved is that someone was killed. And so if a prosecutor sought murder in the first degree charges against that individual, the jury is going to acquit. The jury is going to say you could only prove one of those elements. You couldn't prove the other two. Okay? But let's say the prosecutor charges them with manslaughter. Okay? Unintentionally killed someone while breaking the law. Well, street racing is illegal. They're breaking the law. You've got your three elements. You've proved manslaughter. Okay, I'm belaboring the point, but you get the idea. For everything that you accuse a person of in court, there are elements to that, little pieces that you have to prove in order for that charge or that accusation to stick, and we call those case elements. I like to think of it as like ingredients. If you've got a piece of bread and it's got some peanut butter on it, that's a sandwich, but it's not a peanut butter and jelly sandwich, because a peanut butter and jelly sandwich also has jelly. You kind of see where I'm going with this? If you take away one of the ingredients, you haven't proven the thing. Okay, so let's get back to negligence. The elements of negligence in most places in America, you have to have a duty not to harm someone. The duty has to be breached through some conduct. The breach of that duty has to cause the person to suffer damages. So I like to think of it in 4 elements. Some people combine the last 2, doesn't matter. So duty, breach, causation, damages. Well, if you think about that, that's a pretty workable system that's going to apply to just about any injury scenario you can think of, okay? I go to the dentist. The dentist is giving me an injection, but he pushes too hard with the needle and he stabs through my soft palate and damages nerves up close to my brain, let's say, okay? Well, let's look at that in the negligence context. Did he have a duty to not hurt me? Well, yeah, he's a dentist. He's a doctor. He takes the Hippocratic Oath. He promises to do no harm to you. And then, of course, there's laws that impose responsibilities like that on him. So he has a duty. Did he breach the duty? Arguably he did, right? It may turn out that that just happens on some people and it's unpreventable and there's nothing a dentist can do to keep it from happening. I suspect that's not the case. I suspect it's because he got a little overzealous and he used an unreasonable amount of force. And so we say, okay, he breached that duty, or at least that's the argument you'd make to the jury, okay? Then, was his breach of the duty the cause of the nerve damage? And did the person actually suffer damages, meaning losses, something negative, a negative outcome, loss of money, pain and suffering? We'll get into those in more detail in a little bit, but did the breach cause that thing to occur, okay? In any negligence case, your lawyer has to argue and prove each one of those elements based upon what we call a preponderance of the evidence. So in other words, preponderance of the evidence basically is like the verbal way of describing like the scales of justice. When we're considering whether all the elements have been proved, the jury has to think that the guy who's proving it, there's a little more weight on his side of the scale. That's all it takes. It doesn't have to be he proved it beyond all reasonable doubt or anything like that. It's just he proved it a little bit better than the argument against it, okay? So you can apply that scenario to a car wreck. When you're driving a car, do you have a duty to look ahead and to pay attention to what's happening on the road ahead of you? Yes. If you take your eyes off the road, have you breached that duty? Yes. If you rear end the person, has your breach caused them to suffer injuries? Yes. And have they suffered damages in the form of pain and suffering, mental anguish, lost wages, whatever? Yes, right? What the beauty of this idea of negligence law is it provides for you one kind of just universal way of holding people accountable when they do something foolish or careless, rather than an infinite number of very specific laws. I mean, just think about how crazy it is. Don't throw rocks at people. Well, that would be a law. Don't bump into people when they're on an escalator. That would be a law. Don't try to direct someone in traffic, like you can see better than them and you're waving them on, and then they get hit because there's a car there that you didn't see. You need I mean, think of all the scenarios. Don't rear end people. Don't run stop signs. It would just go on forever, specifically in the injury context, contemplating all the different ways that an individual could be careless and hurt somebody. Or the better approach is you just have the negligence rules. You have these 4 elements, and it just is like the little hat that you put on any given scenario. And that's what most personal injury lawyers do, myself included. Most of our cases are negligence cases. Now, sure, do we sometimes get calls where someone says, hey, I was at a spa and one of the spa employees came up and physically assaulted me? Yeah, that's not negligence. That would be an intentional act. And so we would have other elements we'd have to prove in order to win that case. Or do people call us and say, you know, actually I was hurt, but I was hurt by my psychologist. My psychologist engaged in some wrongful conduct unintentionally, and it ruined my life and caused all these problems. Okay, well, that's not going to probably work with just the generic negligence cause of action. There's going to be something specific to that type of individual because they're a special individual. They're set apart from the rest of society. But for most stuff, you're going to have a lot of opportunity to use that negligence argument. And so when we talk about personal injury law in the modern era, we're mostly talking about negligence law and then a little bit of other stuff.